Correct.
Good morning. Are you Stephanie Martin?
Yes, ma'am.
Give me just a second, please. Will your client waive the formal reading of the indictment in each case? Yes.
Right away, this tells experienced viewers something important. This is not a trial day. When the defense waives the formal reading, it usually means negotiations already happened behind the scenes. The courtroom drama you expect? That already occurred in conference rooms long before cameras rolled. Today is about final consequences, not arguments.
All right, Ms. Martin, in cause number 20, let's see where am I start? Which one's being dismissed?
It's indicating 247.
In cause number 24, DCCR 0248, you're charged with the state jail felony offense of possession of a controlled substance from October 1st of 2023. The indictment alleges that you were previously convicted of possession of a controlled substance on August 24th of 2015. And then after that was final, you were convicted of possession of a controlled substance April 11th of 2016, and also convicted of fraudulent use of identifying information on April 11th of 2016. And how do you plead to that charge?
Yes.
And are those prior?
Notice how fast that answer comes. No pause, no hesitation. That matters. A quick guilty plea often signals acceptance of a negotiated deal. But here's the legal twist. Admitting prior convictions doesn't just acknowledge history. It actively increases punishment exposure. Every yes, ma'am, is legally stacking weight onto the sentence.
Offense is true.
Yes, ma'am.
And then in cause number 23, DCCR 1850, you're charged also with the state jail felony offense of theft with previous convictions. Well, not also, but in that case, that's what you're charged with. And that's from July 14th of 2023. The indictment alleges you were previously convicted of theft August 14th of 2001, March 15th of 2006, September 8th of 2014, August 24th of 2015, April 11th of 2016, July 31st of 2018, January 28th of 2019, and then the indictment alleges those three prior other offenses of the possession of a controlled substance in 2 cases and that fraudulent use of identifying information. And how do you plead to that charge?
Yes.
And are all of those prior convictions true?
Yes, ma'am.
In cause number
Listen carefully to those dates. 2001, 2006, 2014, 2015, 2016, 2018, 2019. Courts don't just punish single incidents. They evaluate patterns. Legally, repeated theft turns what could be minor offenses into felonies. The justice system escalates when rehabilitation doesn't happen. The real question becomes punishment or prevention.
25-0376, you're charged with the state jail felony offense of theft of property with previous convictions. This offense date is from February 7th of 2025. It alleges all of those same prior theft offenses as well as the same prior state jail felony offenses. And how do you plead to that charge?
Yes.
And again, are those prior convictions true?
Yes, ma'am.
And then finally, in cause number 25-0375, you're charged with the state jail felony offense of theft with previous theft convictions, and this is from February 18th of 2025. It also alleges all of those same prior theft cases as well as those other prior state jail felony cases, convictions. And how do you plead to that charge?
Yes.
And again, are all of those prior convictions true?
Yes, ma'am.
In each of these cases, did you enter your pleas of guilty and true freely and voluntarily?
Yes, ma'am.
And did you plead guilty in each case because you actually did what they've charged you with?
Yes, ma'am.
In all of these cases, I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
This moment might sound routine, but it's constitutionally critical. Judges must confirm a plea is knowing and voluntary under due process protections. If the defendant later proves confusion, coercion, or misunderstanding, the entire conviction could unravel. This checklist protects both the defendant and the court from future appeals.
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Martin is not competent?
No, Your Honor.
All right, Ms. Martin, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 250375, find sorry, okay. In 30735, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft with prior convictions. Find all of the prior convictions true. Sentence you in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And clause number 250376, also find sufficient evidence to find you guilty, and at this time find you guilty of theft with previous convictions. Find all of the previous convictions true. Sentence you in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Clause number 23, DCCR 1850, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft with previous convictions. Find all those prior convictions true. Sentence you in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit for that on that sentence for any time that you've been in custody that the law gives you the right to receive. And clause number 24, DCCR 0248, also find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of possession of a controlled substance. Find all of those prior convictions true. Sentence you in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These will all run concurrently, which means together at the same time.
Here's the part most viewers misunderstand. You just heard 7 years, repeated 4 times. That sounds like decades, but listen closely. The sentences run concurrently, meaning at the same time, not back to back. Instead of 28 years, the total exposure becomes 7. This is where plea bargaining quietly reshapes someone's entire future.
Possession case out there that Beaumont PD has, but that they haven't, either the labs haven't been done or whatever, it hasn't been indicted yet. What they're saying is they're not going to pursue that case. So it will not be indicted. You're not going to have to come back here and take care of that case. It's kind of like it's being dismissed before it really gets indicted. Does that make sense? Okay. Did I print all 4?
Yes.
All right, so I'm going to hand you, in all 4 of these cases, the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishments I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. Yes, ma'am.
I'm sorry. Can I say what? Those are my kids right there. Can I just tell them bye?
From here, yes,
I'm
ma'am.
sorry I let y'all down. And I'll see y'all when I come home, okay?
You good?
I love you, bitch. I love you.
So, Ms. St. Clair, the thing to do is to take advantage of any opportunity you have while you're in custody so that when you do get out, you can be a part of their lives, okay?
Yes, ma'am.
All right.
See y'all in 2.5. I love you.
Chris David,
And this is the hidden trade-off of plea deals. Charges disappear, uncertainty ends, and sentencing becomes predictable, but rights are surrendered along the way, including appeals. The system gains efficiency, the defendant gains certainty, and everyone walks away with compromises. Justice in plea court isn't about winning. It's about negotiating risk,